All right, good morning, everyone. This is Curt Ferrone.
And Brad Pinsky.
All right, and we're here for another edition of Fire Law Roundup for April 17th of 2023. Brad, take us away.
All right, so, it's like we're going to start off with a couple of deceit cases, which I'll say. One is not surprising. We have a woman in North Carolina charged with stealing money. That's really all we know, except I didn't see how much money. I don't know if it's even there, but she's required to post a $300,000 bond. So one would assume it's probably a lot of money, but nonetheless, she stole it from the Stumpy Point Volunteer Fire Department. We talk about this stuff all the time. I don't know that we have to give this any more time other than, please, everyone, you've got to start putting in better financial controls. Stop trusting everybody that they're not going to steal from you, because I will tell you, it is always the person you trust who is stealing from you. So stop trusting everyone. Treat them like you don't trust them, and then you won't have an issue. So I don't know if we have to talk more about that, but
no, I think it's an interesting case, and I'd encourage folks that are concerned more about that. Go to Kelly Paxton's blog. The link is in my blog, and Kelly's got a great deal of information. I do want to emphasize, women are not more likely to steal. Okay, that's not the lesson. It's just that they're not less likely to steal, which is what I think most men anyway, most men tend to think that women are more trustworthy, and that, if someone wants to step forward to take a position, whether it's treasurer or bookkeeper or whatever it may be, that we can let our guard down, and just, they're human, and this is a human problem.
Yeah. And hey, if I could do a free plug for one of my businesses, fireservicefinancials.com, fireservicefinancials.com. You can look at our site. We will do the bookkeeping for you, and we're independent, and we don't get control of the finances. So when we look at the books, we're looking at every receipt, every check. I mean, we're kind of doing this for you, making sure that nobody's taking money. So if anyone has any interest, look at fireservicefinancials.com. And, unfortunately, and not to get too much off on this one case, but, treasurers are very tough to find. Yes. Right. We know the volunteer fire service is dying off, unfortunately, way too quickly. And the first to go really are the treasurers, and treasurers are tough to find because it takes a lot of work to understand QuickBooks and, different accounting methods and reporting requirements. And so I get how we always leap to, oh my God, finally, there's somebody willing to do it. But just because they're willing doesn't mean they're qualified or trustworthy enough to do it. So don't just hand over your financials to somebody just because they're willing. And maybe that's part of what happens here.
Yeah.
Okay. Let's head to Indiana. I know Muncie, Indiana, only because this is where we're headed.
I have some history there myself.
Yeah. Oh, really? I dated a girl from Muncie for a very long time.
You and me both.
So Muncie, this is really interesting. I watched the news story about it. It's still developing. We don't know as much other than this. There are two exams at issue, the EMT certification exam and state firefighting exams. And at least on the EMT, and I watched this article a couple times just to make sure I understood what they're saying. On the EMT side, and I kind of scratch my head at this. I'm interested to see what you think. On the EMT side, apparently members of the department were collecting exam questions as they took the exam, and they were handing out answers and exams. And apparently this is, some concern. They call it cheating. If that's what's happening,
call it cheating. Some call it being helpful.
Yeah, right. But wait a minute. On every exam I've ever taken, there are past prep questions and test questions, and unless somebody's signing, because I kind of having trouble with this portion of it, unless somebody's signing something saying, I will not remember the questions and I will not tell anyone what's on this exam, which you can't do. I'm curious how there's cheating, right? They just telling somebody what was on your exam isn't, in my belief, cheating. And I should say I have a client who's close to the National Registry. It's not the National Registry, but somebody who works closely with them. I don't want to go too much off on that, but I was going to have a discussion about that. Like, wait a minute, we give test prep questions all the time on every type of exam, including civil service exams. So how is this cheating? But nonetheless, there is an investigation. That's all it is, not charges, investigation into cheating on the EMT exam. And then the same is true on the fire exam, that apparently they are, cheating. And we don't know on that side what the allegations of potential cheating are, but I'm a little scratching my head on how is this even cheating just because you're writing down questions of what was on your exam. If people are concerned about that, then don't keep using the same questions.
I know from my experience in the thousands and thousands of recertification classes and recertify this and recertify that and attend this and attend that. And at some point, a lot of this stuff just becomes a check the box activity where somebody downstream they have set a requirement that you have to pass a test. It's a pro forma kind of thing. It's not a big deal. And so the answers are freely in the room. Sometimes the instructor's there and so on. And it's more of a check the box activity versus I've also taken exams that are particularly promotional exams, but also some certification exams. And I'm not talking about annual or every 3 years recertifying EMT or paramedic. I'm talking about, certifying for paramedic or certifying for firefighter 1, firefighter 2, where, there's an expectation of that there's integrity in the process. So if you can kind of separate out the ones where it's just a check the box activity from where there's really an expectation that you're going to show that you have the knowledge in order to gain something. And it wasn't clear to me from what I saw, which of those is really in play, but I can also see people who want to get a fire department in trouble call the check the box activity something that it really isn't. It's just, like CPR, how many, oh God, I've been doing this 50 years. That's right. At least 50 different CPR recertifications. And every time you do it, the rules are different, by the way. So,
right.
But bottom line is there's, I think, a couple of different fact patterns. And I do know some people, for whatever reason, they're in trouble themselves. They want to get somebody else in trouble. And they'll say, well, they were cheating on exams. And when really it's not, it's just not that kind of thing. If it was cheating, then obviously, the chips are going to fall where they are or where they may.
Right. And look, the chief on the interview is like, I don't know, I hope it's not true. It would put a bad light on everybody. Sure. I thought he did an okay job. I just, I think I would say, listen, let's wait to see what the investigation reveals. But I was just scratching my head because it just didn't seem like cheating to me to have test preps and to share the questions that were on your exam. I don't even know that they could swear you to confidentiality. You can't tell anyone what questions are on there. I mean, that would be insane. So
what do they, I forget what they call it, but the integrity of the exam. I know in the bar exam, this like highly, there's a lot of security around the questions. And if there's a potential that the answers have leaked out, they have a backup exam ready. So like the exam in July, if you're having the exam in July, the exam that's going to be like the next January or February is like the backup exam. And then if there's no security issues. And so that's an example of, to me, that's a high security type of
sure.
process, but you and I, if you took the exam in July, you and I could talk and I could take the exam in February. There's no, but on the other hand, there's CPR exams where anybody who's a CPR instructor has all of the questions, all of the answers. And sometimes the instructors will stand in front of the room and say, just make sure you know this number, make sure you know this number. And we've all been in classes like that. So in that case, is that really cheating? I
just don't think test prep is cheating. And if you take any Kaplan course or anything else, we're always working off past SAT courses, past LSAT courses, past GREs. Anyway, I don't even want to give any more time to this, but I'm not sure. We'll see what the investigation reveals.
That's it.
Okay. So, and this is a lot about a little, right? There's a lawsuit now in Utah. A woman was involved. It took me a couple of times trying to figure out what happened here, but a woman was involved in a crash. And there's a lawsuit now against the responders because they said they injected too much ketamine. And it is a very esoteric complaint lawsuit. It's strange. It looks more like a scientist than a lawyer wrote it. But it's on camera apparently. And they're saying, hey, there's not much question. My only question with ketamine is, what was the policy you had to follow, and did you follow the policy, right? Did you act in accordance with what your the administration requirements on ketamine were, right? And if they did, they should be okay. If even if it was too much, as long as they follow the policy. If they didn't and it was discretionary, well, wait a minute, maybe there's an immunity defense based on discretion. Or on the other hand, maybe it was inappropriate. But all we have now is an allegation. You made the point in your blog that they didn't sue the driver who actually was arrested, who caused the crash, who was actually arrested and I think convicted of murder.
He was convicted of murder. Yeah.
Yeah. So, geez. But we don't know much more. I will say ketamine, you would know better. That word ketamine just keeps coming up into so many of these lawsuits.
Yeah.
So many things are based, it seems, on ketamine, as opposed to morphine or any other drug we've seen before. Ketamine is now like just filling all these lawsuits. I don't know.
It is, and I think that's unfortunate. My son, Andrew, is a surgeon, and I remember when I first read about it, I asked him, I said, what's up? Do you guys use that? He goes, Dad, we use it all the time.
Yeah. Oh, yeah.
We use it all the time. It's got outside of the hospital is a little different than in the hospital, but outside of the hospital, it's the risk of a mistake has much more dire consequences. But the sort of flippant use, I think one of the problems with ketamine was it was being used or was being requested by law enforcement. Yeah. From the paramedics, and paramedics were administering it to patients, not for medical reasons. Other than so they wouldn't have to wrestle or fight with the person. But, I think the term, as I understand it, the term is dropping them down the K-hole.
Yes, that is exactly what it is. I've heard that many times.
Night.
Yep.
But
look, it's a horse tranquilizer. I mean, this is serious stuff,
So, I don't know. We'll see. If it's a beneficial type of medication, I hate to see it pulled off because of hysteria about it. But certainly we do see an awful lot of litigation. Much more so, I don't recall seeing anywhere near the amount of litigation on any other med that we administer. I could be mistaken, but I don't recall, just anecdotally. I could go through my database, but I don't. In fact, I have a category for ketamine in my database, and there's no other medication that has even approached that the need for a separate category. And you think we've had fentanyl, we've had morphine, and
that was my thought. Other than fentanyl early on, right? We've never had anything like this. But I think the lawsuit fails. I'm just going to give my prediction for something that was said in the complaint. They said it was a very rare side effect, right? And I think once you say that it's very rare, well, then how's anyone supposed to know? I think that's an uphill battle. Also, you've got the proximate cause issue. If it goes to trial, she's already a seriously injured patient with a head injury. And now you've got to prove that the ketamine caused the death and was the only thing that would have caused the death, and she would have survived otherwise. It's a very tough suit, frankly.
A couple of factual questions in there. One was the allegation is that CPR wasn't started immediately, which I find hard to believe, and I guess you'd have to look at the video, but that was one of the allegations. There's also an allegation that I think the dosing was 500 milligrams, and apparently the medic who prepped the vaccine, prepped the shot, or prepped however they were getting it into her, didn't expect that the medic who actually pushed it was going to administer the whole thing. And so again, I don't know about just how much is appropriate for a given weight, given circumstance. So I'm a firefighter. I don't pretend to be a doctor, but
we'll see more on it.
Yeah.
So those first three cases, I kind of put on the interesting thing, but these next two are way more interesting, especially the last one. So now we just have another complaint in Arizona. And I think it's good because there's so many talking points on this, but let me just summarize what the allegations are. The allegations is that there's a firefighter, again, in Arizona. She was terminated ultimately. Okay, so how did she get to the point of termination, and what's the basis of her suit?
She or he? I think it's a he.
Oh, I thought it was a she. Is that a he?
I think it's a he. Yeah.
Oh, okay. It's a he. I can't totally tell. So in any event, the firefighter. So because it's Shannon Glenn.
Right. Yeah.
Shannon's a he.
I believe so. Go ahead and you talk, and let me.
Well, in any event, whatever it is.
My recollection was it was a he.
Okay, the firefighter. Here's the basic facts, but they're important. What I pull out. So the firefighter applies for the job as a new firefighter. On the job,
Mr. Glenn, it's a male. Yes.
Okay. So I was not. Anyway. Okay. So on the application for the first time, he fills out an application and says, "Do you have any prior discipline?" And he says, "Yes." And he answers the question, says, "Yes, and I want to talk about it." And he's then interviewed about the prior discipline. And then, right, so, and he's hired. He goes a couple more rounds, and ultimately he's hired. Works for the fire department, and then ultimately becomes a union rep. And as a union rep is very vocal, as they are and probably should be, about alleged improper practices and disparities in how overtime's calculated, whatever, but raises, proper, presumably proper allegations, and then applies for a promotion, or I may get this order a little mixed up, but in any event, applies for a promotion. The same question is on the promotional exam. So, and I do have this because
promotional application. Yeah.
Yep. And the application asks the same exact question, and the firefighter on the application or whatever questionnaire answers the same, right? "Yes, I do, and would really like to talk about it." So within a 3-day period, I think this is what is really going to be the uphill battle for the fire department, right? Within 3 days of this whole thing taking place, he gets fired. He had made complaints about union issue, workplace pay, and et cetera issues, and then gets fired within 3 days of making those comments, allegedly. Again, this is all allegedly. We don't know yet, just a claim, but gets fired. And the basis for the termination is you lied on your application, which that's going to be very tough. To me, looking just at a 100-foot view here, you hired somebody under the same question, answered almost identically twice. You hired the person, didn't say they were lying then, right? You didn't fire them at any point, and now you get the same question, and yet within 3 days or so of some trouble the union person's creating for you, you now turn around and use maybe an answer to a question that really wasn't false or didn't cause you an issue the first time. Now, listen, in fairness, if there was a lie both times, but you only caught it the second time, hey, you can fire somebody. They lied. It's not pretextual. But that's the whole question. Is the alleged lie on the answer, is that pretextual or was it accurate? And that's what we're going to see. That's a fact question, but if nothing more, and again, this is just the lawsuit, right? So you're only getting one side, but it looks bad. And the burden is going to shift to the employer to say, no, you really did lie. We can prove the lie. We didn't catch it the first time because, and it matters to us now.
Yeah, and I think the assumption here is that the lie was about the termination from his prior fire department, but the lie could have been something totally different. And the accused is trying to say, no, this is why they fired me. And the fire department's going to say, no, that's not why we fired you. This is why we fired. So again, we only get half the story. We're not 100% sure of what the fire department's response is going to be here.
Right. And really, look, the hard part is it all happened in such a short couple of days.
Yes.
Right. That's the head scratcher, right? When somebody says, okay, why? And
if you're gonna go back, let's say you have an employee who's creating union problems for you, okay, that's not the time to go back and look at their application,
right?
To see if you can find a problem.
Right.
You may want to, you may be tempted to, but there's a timing issue that has to be taken into account.
Yeah, it just looks bad. But look, you and I have said, I think we said last week, right? If you really have a basis to terminate someone, don't be afraid. Just document, right? But This one is an uphill battle for, I think, for the fire department. But again, as you said, we only got one side.
Mhm.
Okay, let's focus on a really, really interesting case. I'm going to slow down and go through these facts less in a summary manner than I just did, because I think this is really interesting and is a good law school, right? We always talk about how our viewers, if they listen to us and kind of struggle with the issues we're struggling with in some of these, you'll really learn a lot. You'll develop professionally a lot. So I want to kind of slow down because this is a really good professional development case. I actually lecture on this topic a lot. I love this case. So here's what we have. We have this Fifth Circuit down south. So that's Texas and Louisiana is mostly the Fifth Circuit. So we're in Texas here. We have a fire captain who files suit against Montgomery County Emergency Services. And she was fired, allegedly, but she was fired for repeatedly failing the new fitness assessment. So I want to focus on new and fitness assessment. So she, as you can imagine, is going to claim this is discriminatory. But let's go through some of this. She first says that her retaliation was not for failing the physical. She claims, and this is very important to the court, you'll see why, she claims that her termination, that was just pretextual, that her termination was actually because she complained about a former fire chief's sexist comments. And she also kind of throws in that the new physical test is discriminating against her based on her gender. So the Fifth Circuit is look, most federal courts of appeals circuits are pretty smart and they all have their bents a little bit, right? Some are pro-employee, pro-employer, they bend different ways, but this is a good court. So this is a big decision and this is an appeals level decision. The only thing over this is Supreme Court, which this will never get to. So it's important to listen to what these courts say. So here's what the court says, right? Now, this is not allegations like we have with a complaint. This is a decision, so I don't have to say allegedly. This is what the court found and held. So Crivelli was the firefighter. She was hired, I forget when she was hired, but in 2017, they hired a chief. The defendant hires a chief. The chief promoted the plaintiff, Crivelli, to captain. And this was the first time a woman obtained this rank in Montgomery County. So that's a big deal. Shortly after taking the office, the chief changed the physical fitness assessment, which the court will later say you have the right to do. So don't be afraid to make your physical fitness assessment better. In any event, it previously had activities like climbing ladders, carrying dummies, dragging hoses, which sounds very much like the CPAT for anybody who takes that, because that's exactly what's in it. But the chief wanted to redesign the standard to more closely mirror the United States Navy's physical standard, which, again, the courts can say totally had the right to do. So here, firefighters were required to perform 3 exercises, right? Sit-ups, push-ups, and either a timed run or a rowing exercise. But the difference here is this assessment, which I find very interesting. I haven't seen, normally you try to avoid this, but yeah, this assessment is age and gender adjusted. Right. So here what age and gender adjustment is, there are different standards based on your age and there are different standards based on your gender. So for example, the court says 31-year-old, right? The 31-year-old plaintiff here was required to do 13 push-ups. So as a female, but a man of her age would have had to do 35, right? So they change it based on age and gender. I think that's really interesting as a general matter. You and I could talk more about that after we get through this. But so the point, the main part, the court says the gravamen of her complaint, the main thrust of her complaint is that she says she was terminated for repeatedly failing the new physical fitness assessment. Now, her facts aren't great for her, and these are important facts, right? So first of all, 4 other individuals never passed the test, and all of them were men, and all of them were terminated or resigned. So right off the bat, we're not seeing that she's treated differently than men. That's very important to point out, as you're going to see in a minute. Moreover, every single woman except for her passed the test on the first try, giving a pass rate of 80% for women, but men was 77%. So when you talk about disparate impact, what were men affected differently than women? Yeah, but the women are doing better, right? So Title VII of the Civil Rights Act of 64 makes it unlawful to discharge an individual because of their individual sex. So you can prove that through, direct evidence where, hey, I'm telling you, I, discriminated against you.
You're fired because you're a woman.
Yeah, exactly.
But that would be direct. And we very, very rarely do we see that kind of a case. It's usually circumstantial.
Yeah, and you don't see it because, one, if you could prove it easily, you just settle, right? It should never reach the courts. But it's always circumstantial. So here, when there's a circumstantial evidence for our long-term viewers, you're going to know what we're going to say is McDonnell Douglas. It's a burden shifting, right? So first, the plaintiff has to make a basic case, a prima facie case of discrimination, that you discriminated against me here based on my sex. And she doesn't really say age.
I'm a woman and I've been fired. That's
right.
And
that's all it takes.
And I think I'm qualified. So
Yep. That's all that takes. So that's a very low burden, right? To show you're part of a protected class. And then it flips over to the employer, and the employer has to come forth with some legitimate non-discriminatory reason for the employee's termination. Right. And if the employer can show we had a legitimate reason, like here, you failed the exam, right? You failed our physical exam. Then the plaintiff now have them back and say, yeah, but that's not truthful. That's what we call a pretext. And I've said that a couple of times on this in other cases. But a pretext, it's a false reason, right? You say it's because of, I failed the physical, but it's really because of my sex. I think, though I don't think they could have won, you're going to see in a minute where I think the court's saying, plaintiff's lawyer, you kind of messed this up. And you'll see that in a minute. In any event, the court holds that because she failed the physical assessment, she was not qualified for the position. So the court says, the employer as a fire department is free. And I love this line because I'm going to use it in a million things I do from now on. But the employer is free to create and reevaluate and change their physical requirements. We're not going to mess with the employer. That's their prerogative, to quote someone's song. And I think that's a great standard, right? You are free to create physical assessments. Now, they can't be discriminatory, right? They have to be fair. But here's where the plaintiff's attorney screws up. The plaintiff's attorney never alleged the disparate impact, right? Now, there's disparate treatment and disparate impact. I can explain that importantly. Disparate treatment says, I treated you differently intentionally, right? I meant to, I treated you differently. Whereas disparate impact is what we call a facially neutral policy. So on its face, the policy doesn't say we're going to discriminate against women, right? On its face, the physical policy says we're going to test everybody and they have to be tested. And it doesn't look like we're targeting women. A disparate impact would be, even though the policy appears to be facially neutral, on the other hand, the impact does have a disparate impact. You see this in civil service exams. You see it in a ton of policies that, well, I'll give you an example of one.
This is where we get into the statistical problems, because in order to prove the disparate impact, you've got to show data. You have to show that this particular requirement burdens one protected class more than it does the majority.
Right. And I think based on that, the court is saying, listen, you didn't plead it, but you would have lost it, right? Because 80, 77, there is no disparate impact. And let me give you an example of one that will ring with a lot of people. We say, well, everybody has to be clean shaven, right? And you can say, okay, well, that's a facially neutral policy. Everyone's got to be clean shaven. And yet some races and religions come forward and say, yeah, but it disproportionately impacts us because we have to have a beard, or because I have a medical condition, and that medical condition is only, is more prevalent in African Americans than Caucasians. So that's a disparate impact, right? It's facially neutral, but it has a negative impact. So here the court just really comes forward, other than saying you kind of screwed up the pleadings. But I think for the reason you said, Curt, they never would have won, right? The statistics wasn't in their favor.
You know, what I think is really interesting in this one, change one of two possible fact patterns, and this would have come out differently. Okay. If there were men who failed it that did not get fired,
Oh, yeah,
she's
totally.
going to win. That's number one. Okay.
Yeah.
If all of the women or most of the women who took the test failed, she's going to win.
And that's disparate treatment.
Right.
Well, your second one,
that's
your
impact.
first one's
It's
disparate
impact.
treatment. Your second one's impact.
Second one, right. Okay. Change either of those and she's going to win. But she, you know, the fact that the city's going to win both of those, the court was like,
right.
That's the end of the line.
And that's where, let's go to the statistics, right? Even though she didn't plead the disparate impact, right? It's a good lesson for all our administrators and future administrators. You want to look at the effect of your policies to make sure they are not only facially neutral, but what's called factually neutral, right? And the statistics, as you point out, are what you look at. And right, like if this had been 80% of the males passed and 5% of the females passed, had they pled it, I agree, they would have lost. But it's a good lesson to everyone is, listen, if you're made the right decisions, you're treating everyone fairly, you're firing the men and the women who all failed, and your test is producing, my God, that's pretty good. 77%, 80%. That's pretty darn neutral. I think you win. But it's strange. The most subtle point I always like is what the court said, which was no big deal with the court, is look, the employer has the right to change its policies anytime they want, and we're not going to second guess their ability to change the policies. You'll hear it too, so many times where they say, oh, but the historically, this is what we've done, and we can't change that. What do you mean we can't ever change what we've done? Past practice? I hate that. Past practice is this. Okay, well, if the past practice isn't working or could be better, we change it. Right. So I like this judge saying that he or she didn't, the court, the panel didn't get hung up by past practice at all. So yeah, you can change it all you want.
Right.
All right. That's really it. I love that last case. I think that is such a good case to talk, and maybe should be the shorts, but people should really look at this because that's, when people say, oh, your policies are discriminatory, now you'll be smart enough to say, well, are they factually discriminatory, statistically discriminatory? What do you think? So this is a good law school case, and law schools spend a lot of time on disparate impact. All right. And that whole distinction, because I think lawyers screw it up. And here I'm not picking on the lawyer, but they did not plead it. And I'm surprised they didn't plead it. Their failure to plead it was a tacit admission in mine, right? Well, you looked at 80 and 77, but this is really a good lesson for everybody, and I think people should focus on it a little bit at the administration level.
That's it. All right. Well, that's going to do it for another edition of Fire Law Roundup. If you haven't already subscribed, please do. If you like what you heard, please click like. If you don't, email Brad. All right, and we'll see everyone.